Good morning. I want to discuss some of the arguments and defenses in corporate climate change litigation, and I will do so in three parts. I will start by looking at some of the most relevant litigation in this area. I will then quickly highlight some of the common hurdles and finish by underscoring global perspectives and prospects for climate change litigation. In terms of some of the most visible and significant cases, the case of Uganda Foundation versus the Kingdom of Netherlands is material. In this case, the Dutch Supreme Court established precedent by observing that corporate emission reductions positively contribute to climate change mitigation, and that ties up with the defense of diffuse responsibility, which is to the effect that emissions by a corporate entity are so diffuse as to constitute a drop in the ocean, and such a corporate entity need not bother with them. That defense has been rejected. Similarly, in the case of Milieu Defensive versus Royal Dutch Shell, the court rejected the defense of perfect substitution, which presupposes that even if a corporate entity were to stop emitting greenhouse gases, the portion that that corporate entity has foregone will be substituted by another company which will take up those emissions. The court in the Royal Dutch Shell case therefore asserted the duty of corporate entities to protect human rights and to reduce their greenhouse gas emissions. But similarly, in the case of Luya versus RWE in Germany, the responsibility of corporate entities in climate change impacts has been upheld, and in that case, the plaintiff is claiming 0.47% of his costs, which should be covered by RWE, which should be a correlative contribution by RWE in terms of global climate change impacts. What would be some of the hurdles? The first one would be causation. There is a difficulty in creating a causal link between the harm suffered by a litigant and climate change impacts. In order to address that causal link, there are significant developments in attribution science that attempt to establish a nexus between harm suffered and climate change impacts. In many jurisdictions, the right of standing, also known as locus standi, has been a common hurdle. A litigant is required to demonstrate the loss suffered as a basis for them to file a claim. The practice is varied. In Kenya, the Constitution and the Climate Change Act have dispensed with the requirement for locus standi. Another hurdle would be the political question doctrine, and this would simply imply that the matter that a plaintiff invites the court to adjudicate lies within the political sphere and not the judicial sphere, and as such, courts should not involve themselves in such question. And this point came out very clearly in the Ribnik and Lutz cases, as well as the case of AEP versus Connecticut in the United States. Perhaps another hurdle that I could highlight is proximity, where a litigant desires to establish a cause of action in negligence. It will be very difficult for such a litigant to demonstrate, but indeed the harm suffered was proximate and foreseeable, and this challenge has been particularly visible in Australia. In terms of the global perspectives and prospects, I could perhaps highlight developments in India, where the failure to warn arising from the Bhopal gas tragedy resulting in violation of human rights has come to the fore as a basis upon which litigants could possibly found a corporate climate litigation claim. Looking at France, the BNP Paribas cases have been instrumental in providing a potential cause of action under the French Commercial Code, which then requires a plan of vigilance for environmental change. In Italy, violations of Article 2 and 8 of the European Convention on Human Rights, as well as several provisions of the Italian Civil Code, have been basis for bringing cases before court. Therefore, depending on the diverse jurisdictions, it is possible that going forward, there will be a number of innovative bases upon which individuals or plaintiffs can found corporate climate litigation claims. Thank you for your attention.